This is my wig, not to be confused with the bob.
So I can't have a wig or a butt?
So when I have on this wig, is my microphone on? It is. We're going to read the ex parte hearing, the transcript from the ex parte hearing with Judge Glanville. The transcripts were released, baby, and let's get into it. I'm going to read it out loud or live. I've not read these transcripts before, so let's see what they got to say, child. And if you are not up to date, baby, it's too much to keep you up to date on. You got to go back and watch the prior videos. But yes, let's go into these transcripts. I'm sorry I'm late, you guys. I had a side quest I was doing. Don't ask me what the side quest was. It was something that I did not have time to be doing, child. But I had a side quest that I was doing. Wait, why aren't the slides going to the Puriana? Okay. So already we seen here that the assistant district attorney is in here, Kayla Bumpus is in here, the attorney for Kenneth Copeland, the court reporter Christina Weaver, and investigators Antonio Long and Rashid Hamilton. So that's not I thought somebody told me there were like 14 people present at this hearing. That's definitely not giving 14 people. So yeah, this does not look like 14 people, but whoever said that could have been exaggerating. So let's continue reading on. And I don't know, maybe I'll put some music here while I'm reading. I don't know, but hopefully something for your reading or your viewing pleasure. So right off the bat, we have here the attorney, Mr. Melnick, saying he relayed to the prosecutor on Friday that he had never heard of statute 24-5. Here's that statute. And if you watch the other video, you'll know this statute basically says that when you have immunity, and if you're granted immunity, for example, like Kenneth Copeland was, and you don't testify, then you can be held in contempt. So what the ex parte hearing transcript here says is that Mr. Melnick apparently emailed the district attorney, Attorney Love, and said that he had never heard of that statute before. I don't know. I mean, that seems odd, but let's keep reading. Oh my God. Oh, this is spicy. So right here it says the prosecutor wrote back to the defense attorney, whose interest are you protecting? Yours or Mr. Steele's? Whose client are you protecting? Whose client? Yours or Mr. Steele's and Mr. Sharp's? That's really offensive. I'm not gonna lie to you. So the prosecutor here then writes back to the defense attorney, and it looks here like there's an accusation or a question, at least, as to whose interest are you protecting as a defense attorney, your client or someone else's client. That's really offensive because you as a defense attorney, you are always trying to protect your client's best interest. So to have the prosecutor who's trying to put your client in jail try to indicate or try to make it look as though you don't have your client's best interest at heart when they're the ones that's trying to put your client behind bars or make them testify, do whatever they need to get your client to do in order to achieve their greater aim. They're certainly not trying to protect the client either. So to have that said by a prosecutor is really offensive. So it looked like here the defense attorney responded and said, you are going to get him killed. You're making him a target. Fuck you, is what he wrote in the email. Then we're getting spicy. Prosecutor also says that Mr. Melnick said he's no longer representing Mr. Copeland, which is strange. He's not going to represent Mr. Copeland if he testifies. And the prosecutor again makes that accusation that the defense attorney is not serving in the best interest of his client. That's wild. And then the judge says, well, he's on vacation this week, so that's why he's not in court while his client is testifying. Mr. Copeland had told Ms. Hilton that Mr. Melnick wasn't representing him. So Copeland told the prosecutor that the defense attorney Melnick wasn't representing him. And then rather than Mr. Copeland reaching out to the defense attorney apparently was in communication with other defense attorneys, Mr. Steele and Mr. Shart, and Mr. Melnick reaches out to Mr. Copeland and injects himself in these proceedings. Okay, so what we're discussing was in no way a matter that Mr. Melnick was in no way a matter, and that is where we are not allowed to speak with a person when they are represented by counsel. So the state is saying here that they're not allowed to speak with somebody who's represented by an attorney. Correct? They're not allowed to speak directly to a defendant in a case when they're represented by an attorney. So Kayla Bumpus, the attorney here, is interjecting, saying, well, you're saying he has to stay in custody until the end of how long? I mean, nobody's explained that. And she's saying her understanding is until the end of this trial. And they're saying, no, that's not true. It's until he purges. And again, she still doesn't have a clear answer. But the prosecution is making it seem like, no, she's incorrect. It's not until the end of this trial, but they haven't given her a clear answer as of right now. Here we go again with the prosecutor saying they heard Kenneth Copeland being told by his attorney, Mr. Melnick, or I guess not his attorney, Mr. Melnick, I don't know at this point, that the state was going to hammer you if he testified. So here, Mr. Bumpus comes to Mr. Melnick's defense and says, well, Mr. Melnick doesn't want to represent the defendant, Kenneth Copeland, anymore because he doesn't know everything that was said when he wasn't present. He doesn't know what Kenneth Copeland said to the state when Mr. Melnick wasn't there. He doesn't have those conversations. And so because of that, he can't accurately represent Kenneth Copeland when the time comes, which is now. Here comes the prosecutor again saying there's been this assertion that people are representing his, and I guess you want to say best interest, but their biggest concern is his best interest, and then they are just not here. And Ms. Bumpus is saying that she's not in a position to do that. No, I'm not saying that. I'm not saying I'm not in the position is what Ms. Bumpus is saying. And here comes the attorney, the prosecutor, Ms. Love, again, trying to interject her feelings on this matter of trying to dictate what it is to represent your client's best interest. She says it again. She says, that sounds weird. That does not sound like something in Mr. Copeland's best interest. That sounds like protecting somebody else's best interest. If you talk, I'm not going to represent you, is what she keeps interjecting into the conversation. That's not what I understand to have been said. It sounds to me like Mr. Melnick said, well, I can't represent you adequately because I don't know everything that was said. So at this point, we're on page 14, I think, of like 65, and we still have this confusion or this conversation about what Attorney Melnick was saying, what he meant when he was talking to Kenneth Copeland and when he said he wouldn't be able to represent Kenneth Copeland. And perfect, right here, Attorney Kayla Bumpus has an email that she can just read that was written from Attorney Melnick. So it says here, hey, Kayla, I wasn't able to see Kenneth today. He went on Saturday and tried to talk to him before his flight. That's what Kayla's saying. But I've talked to his family. So at first, Kenneth was going to testify, but now has decided to take the fifth. He may change his mind on Monday. If he does, then he's agreed to discharge me as his attorney. This isn't out of bad feelings, but I was not present when he met with the DA's office, so I can't really help him with his testimony. And then he gave me the discharge, and that's it. So Attorney Melnick said repeatedly that he wasn't there when Kenneth Copeland talked to the district attorney. As a result, he can't really give information or can't really protect him during this cross-examination. So here we see Kayla Bumpus put in kind of this precarious position because the court is saying that she's in the case, the court believes, until it's done. So until Kenneth Copeland's portion is completed, presumably, right? Because it says here, I think Ms. Bumpus is put in a precarious position. She's not the one that stood up and injected herself into this. They reached out to her and she did him a favor, but ultimately, it seems as if Mr. Melnick is stalling and attempting to delay and hamper and hinder our proceedings. And that is a problem because that has nothing to do with the best interest of Kenneth Copeland, and that has nothing to do with Kenneth Copeland's exposure if he testifies. So basically, it sounds like the judge was like, you're in the case at that point in time, at least. So here we see again the court wanting to make this proceeding continue no matter what. They don't care who the attorney, it could be a paper bag standing in for Kenneth Copeland. They don't give a damn. They just want Kenneth Copeland to testify. Look right here. It says there's this whole discussion about whether there was a leave filed for Attorney Melnick. And there was a leave filed, but apparently the court says, well, the leave was not filed in this case. What a leave of absence is exactly that. It gives you permission to go on vacation or not be in court. You have to file that with the court. And if you file that properly, then you are allowed to leave. What the court is saying here is that there was no leave filed in this particular court case. So Attorney Melnick did not have permission to leave. And that's that. So now we have here, again, Ms. Bumpus is like, well, are you going to make me stay in this case, even if he testifies? And the judge is saying, I am, because you're his lawyer, which is crazy because she didn't file an entry of appearance. She was literally just stepping in for that day, it sounds like. And now she's on the hook for something that she shouldn't be on the hook for. It says here, you're a stand-in lawyer at this point. Ms. Bumpus says, Your Honor, I don't have a problem with that. I'm just not ready. And the court says there's nothing to be ready about. Huh? I mean, here's the thing. I think the only thing you've got to kind of ask him about is, look, here's the questions the state is going to ask you. All right, is there anything else that could hurt you that they might ask you about? And as long as you have knowledge of that, then I think that you are fine because the state's only going to get into this. Now, the reason you want to know what's going to hurt you is the defendants know more about Kenneth Copeland than anybody else. So they're probably going to the judge telling you there's nothing for you to be worried about is crazy. There's always something to be worried about when your client is being cross-examined, especially in a case like this one where you weren't on the case from the beginning, you don't know all the information, and you were just standing in. You're not prepared to represent your client in a complex criminal trial such as this one. You haven't even seen the evidence. I mean, this is wild. So the attorney says, what if I say I can't do it? Then Mr. Melnick needs to come back, right? Am I going to be in trouble? Because I was only on here for Monday. That's what I was told. I wasn't given a specific time period that I had to remain here. So there we go. And so here again, you have this kind of back and forth with the prosecutor saying, well, he should testify because we can't prosecute him for anything. Whatever he testifies to, we're not going to look for other evidence to prove that crime. We can't prosecute him for these things, and so he should not be worried about testifying. And you have here conversation where Ms. Bumpus is saying, well, he could be worried about other things such as his personal safety. Here, the court says, do you think that he's fearful of testifying for other reasons like his personal safety? Now I'm reading something that makes me a little uncomfy. And so basically, Kenneth Copeland is not in the room right now. We start off with the conversation between the judge, echo's killing me, the judge, Kayla Bumpus, and, Adrian Love, the prosecutor, and I guess the security, and Kenneth Copeland's not in there. So they go to get Kenneth Copeland now. And Ms. Love says right here, Ms. Hilton has been communicating with him. I'd like to grab her from downstairs and have her come up. So was she talking to him by herself? Why? That's a prosecutor. Why are you talking to Kenneth Copeland by yourself? That's why I got this fuck ass wig on, because fuck ass activities are going on. And now I'm getting irritated. Listen to this conversation right here. So Mr. Copeland is up there, and the prosecutor, Ms. Hilton, is saying, if your concerns deal with being locked up for anything, you can't. Like, there's nothing that can happen. The feds. Ms. Bumpus says, well, that's not. Ms. Hilton says, it is true. Ms. Bumpus says, no, I said that's not his concern. Then Ms. Hilton says, if his concern is safety, we need to know that. Like, that's not expressed. So we don't know what the concern is, so we can try to resolve the concern. How y'all gonna resolve the concern if y'all gonna make him testify, period? This is what I'm saying. Mr. Copeland and I have had conversations before. I understand some of his concerns is potential criminal liability, hence why we gave you immunity. The federal statute of limitations done. The state statute of limitations done. So it looks like there's no federal exposure here and there's no state exposure here. A lot of people had that question. So that answers that. The answer is no. Federal charges, it looks like, wouldn't stem from this. So there's nothing, like I researched it this weekend again. Both those statutes of limitations for what you and I talked about, which is in 2015 or before, done. Okay. So the statute of limitations has run out on those. So you can't be prosecuted for anything you testify federally or statewide, immune, period. So if that is the concern, there's none, because you cannot be prosecuted. The federal statute of limitations is 5 years. So anything in 2015, 5 years would have been 2020, it's done. Anything statewide is 4 years done. So next concern, what may happen in the street? You know what we have talked about, what we can do as far as living and all of that. We've had these conversations. Can witness protection, I'm confused. So I'm trying to express to you, we don't want you locked up. I don't know how many times I've got to tell that to you. And what I've got to say to you, we do not want you sitting in the cab or whenever they got you because of this. I know you wanted to talk to me on Friday before you walked into court. We weren't able to talk. If you still want to talk with or without Ms. Bumpus, I'm here, but we do not want you in custody. You will not, this order, I don't know if you kept your copy of the order, but this order says you are immune from prosecution, any of it. Literally, judge, you might want to close your ears if you confess to murder on the stand. If we don't have any other independent evidence outside of what you say on the stand, you are immune from prosecution from what you say in court. If we don't have any other independent evidence outside of what you say on the stand, so that she's trying to say, oh, you can confess to murder. If we don't have any other independent evidence, that we can't prosecute you for it. Okay, whatever. The prosecution, I mean, it's just hard. It's hard to trust prosecutors because that doesn't mean they won't then go out and try to find that independent evidence. You feel me? Or try to make it seem like they did have that independent evidence. But okay. So again, I don't know what was communicated to you on Friday. I have no idea, but what the state has assured you, which I've assured you in our private conversations with Mr. Long, as I'm saying in front of Mr. Bumpus, as I told you, that is what the order says. All right. So basically right there, the prosecutor was going through the various criminal exposure options that he would have, which are essentially limited, very limited, almost none, right? She says that federally, you would not be exposed to anything because these crimes that you were confessing to, the statute of limitations occurred at 5 years. So the crimes occurred in 2015, 2020, the time period to bring those an indictment completed. Statewide, those felonies that you admitted to 4 years is the statute of limitations. So the statute of limitations would have been over in 2019. It's done. So we can't prosecute you for anything statewide. Federally, they can't prosecute you for anything either that you confessed to that happened back then. If you confess to murder today, we can't prosecute you for that murder unless you bring some sort of, we have rather, some sort of independent evidence of that murder. And we don't have that at this point. So we can't prosecute you based on whatever you say on the stand if that is the only evidence we have of that murder. So that is what the prosecutor was breaking down right there. Here we go. So Kenneth Copeland talked about how the state did this intentionally, called him to testify, knowing that his child's birthday is coming up soon and knowing that if he didn't testify, he would be in custody for his child's birthday. And the prosecutor says in response, when you asked me, what is the one thing that's going to get me in jail? Didn't you ask me that? And what was my response? If you plead the fifth. And that is exactly what you did on the stand, and that's why you're in jail. But what did I tell you before I got to that point is what Kenneth Copeland says. I told you the whole time Tuesday, Wednesday, Thursday that I was pleading the fifth. Ooh, this is a ginormous allegation. So he says right here that he told the prosecutors prior to the time he was called to the stand that he was going to plead the fifth, and they knew that. That's horrendous, because if the prosecutors were aware that he was going to plead the fifth, they should have never called him to the stand, because you are not allowed to have a defendant or a person, not a defendant rather, you're not allowed to have a witness plead the fifth in the case on the stand. You're not supposed to do that. And here he's saying that they were aware and they still let him testify. He pled the fifth and they acted dumbfounded and they knew he was going to plead the fifth. Wow. You said your concern is what they know about you. And when you said that, I said, well, you know stuff about them. And then I said, whatever your concerns are, we can give you immunity. So I didn't tell you I lied on them to get myself out of the situation. Mr. Copeland said, so I didn't tell you I lied on them to get myself out of the situation. So basically he lied and said whatever he needed to say to become free. Ms. Hilton says, you said you were a liar. That's what you said. You said you were a liar. Was this recorded? No. And did he ever say that Mr. Melnick was his attorney, is what Ms. Bumpus says? No. This week, when we first met you in the car on Friday, we asked you, is Mr. Melnick your attorney? You said he's not my attorney. I haven't even talked to him. Yet another strong allegation, essentially that the state talked to Mr. Copeland without his lawyer. Mr. Copeland says, no, I never said he's not my attorney. I said I haven't talked to him. That's different from saying that he's not my attorney. Remember, in the beginning of this transcript, we talked about if you have an attorney and you're a defendant, you are represented by an attorney, the state knows you're represented by an attorney, you say you're represented by an attorney, and the state continues to talk to you, they don't need to do that. And here, he looks like he brought up Mr. Melnick and said he hadn't talked to Mr. Melnick, but didn't say that Mr. Melnick was not his attorney. Wow. The state contests that. Ms. Hilton says, you said he's not your attorney, you haven't talked to him, then we continue to have a conversation. At no point did you ever say, hey, I want Mr. Melnick here. And Mr. Copeland says, well, you made me feel like I didn't need him. You didn't make me feel like I needed him. Then she tries to say, but if you needed him, we would have said, well, if you would have needed Mr. Melnick, we would have said to you, okay, just call him. So, I mean, that's our position. We don't want you in jail. Then she tries to go back to the jail, but did he have an attorney or not? Did you know or not? I don't know. I don't understand why we're kind of skipping lightly over that part. Whatever your truth is and what your truth is, but you just got to answer the questions. We believe that whatever your truth is, we know what you said before. I don't know, what you're going to say on the stand, but what we know is pleading the fifth is going to keep you in custody. That's what I know. Now, how you answer your questions is how you answer your questions. I know what you said before, and I know what you said later. I mean, I know what you said before. So basically now we get back into this back and forth where Kenneth Copeland is like, I told y'all that. And Ms. Hilton says, no, you didn't. And Mr. Copeland says, you said, why would I plead the fifth to something I didn't do? And I said, you don't know what happened. So basically, he had this conversation with the prosecutor and they were like, well, just testify, just say what you did, it's fine. And then he's basically like, you don't know what happened or what didn't happen. I just told y'all whatever. I lied to y'all multiple times. Y'all fell for it. And I said what I needed to say to be free. And now we're here and you're telling me to just testify, it's going to be fine, but you don't know it's going to be fine because you don't know what happened. You don't know what the truth is. So here we find out that the immunity came after Mr. Copeland said he's pleading the fifth. So I didn't know when Mr. Copeland had the immunity. I thought he had it before then. But it looks like he didn't have it until after court on that day. That's interesting. So Mr. Melnick sent the email Thursday evening, 6 p.m. And it looks like Friday morning at some point thereafter, he got immunity. So basically, and my question is, so at this point, we know that at some point, Kenneth Copeland received immunity. I haven't seen it explained yet here if he understood that if he was given that immunity and then he pled the fifth anyway, that he would be in custody until all of the defendants in this trial were tried or until their cases pled guilty or were dismissed or were concluded. That is not something that I see here. So it says here, the state is saying, well, he didn't ask for immunity. He didn't have to ask for it. We gave it to him. That's fine. But now that we gave it to him, it's an order. He can still choose if this is the road he wants to take, then he'll just stay in custody until the trial is over. And when we say the trial is over, every last defendant has been tried, not just these 6, the other ones too. So Kenneth Copeland says, well, I've done longer time, but it's interesting. I mean, it does seem like he didn't understand everything that went into taking immunity from this transcript here. Now, it seems at some point, Ms. Hilton, the prosecutor, had some sort of conversation with Kenneth Copeland where she said something about the only thing that will put you in jail is if you don't end up testifying, if you plead the fifth. but I don't know when that happened. I don't know if that was fully explained. I don't know if he fully understood that or understood how long he would be in custody if he took the immunity deal, because it says right here, Ms. Bumpus is trying to clarify here, like he didn't ask for this. He didn't, I don't know that he understood fully what was entailed in this immunity deal in terms of the consequences that would happen if he decided to plead the fifth while he still had immunity. I mean, that's clear right here, right? It says the state does not want you in custody. What the state would like you to do is purge yourself. Kenneth Copeland says, what does purge yourself mean? He didn't even, so again, were these consequences explained? If he's asking these questions that are tantamount or really important to know before you're going to plead the fifth, and he is just now having these things explained after he's already pled the fifth, after he's already signed the immunity deal, it sounds like there were some failures in communication here, and that's to put it lightly. Ms. Hilton says, meaning that you are no longer in custody and the way you purge yourself is to testify. That is kind of how it happens, and that is what the state wants you to do. We don't want you in custody. I can't say that any other different way, but we don't want you in custody. The only thing that's holding you is you refusing to testify. So here we have Mr. Copeland asking about the questions, about the consequences. He says, and if I don't testify, I have to stay in custody until when? The court says until the trial is over, until all the defendants have been, and I've got 6 that we have right now, and then there's another 6. So Ms. Hilton said, no, there's another 12. So the court said there's 12 thereabout that are still outstanding in various forms or another. So until those 12 cases are concluded, that is how long you will stay in custody. So now it's getting good, because now we have this conversation about immunity and independent evidence. And basically, Kenneth Copeland starts saying, well, what if I get on the stand and I say, I don't recall, or if I say something that's not true, and you know it's not true? Attorney Ms. Bumpus very acutely or astutely, bitch, I'm tired. What's the word I'm looking for? She says, okay, explain independent evidence. He says if he didn't do something and you know he's not telling the truth, what happens? And then you have this back and forth where it says, okay, well, then he's going to be impeached. If he lies, then I'm going to bring up the transcript. I'm going to bring up some other evidence to show that he's not telling the truth. He's impeaching. I can impeach his testimony. He's not going to go to jail for that. Or if he answers consistently, I don't recall, because he's told so many different stories and tried to finesse the situation so many different times, that's okay. He can just say he doesn't recall. I mean, I hope he doesn't say that, but hopefully he tells the truth. And I'm trying to find it where he said specifically, like, I said so many different things, I try to just finesse my way out of it. Right here we go. So he says, if I'm saying something different, this is Mr. Copeland. So when the police question me, they done question me every single time they lock me up. I don't know how many times that was. I done told them a different story each time I could think of to try to finesse my way out of the situation. I don't recall what I done told them. He don't know up from down, baby. He don't know pink from red. Honey, he done told the police whatever they needed to hear. And he says, well, and that's the truth. And the prosecutor says, well, if you don't recall, because you told them so many different stories, just say you don't recall. And basically he's asking about, well, will I get prosecuted for that? If I say I don't recall, they say no. And he's saying, well, what's the only thing that's going to get me locked up? And again, the prosecutor says, well, if you plead the fifth. Now we do have to have a conversation here about independent evidence, because I don't think they explain that well enough for my liking. So basically, if he confesses to a murder, like we talked about earlier, it's going to be hard for the state to prosecute him for that murder. Because they don't have, how are they going to find an independent source to corroborate that murder that was not given to them from the testimony on the stand? Like, they didn't know about that murder until after Kenneth Copeland testified, right? So pretty much everything they get from then on, it's going to be difficult for them to say they had an independent source of that, because they didn't know shit about it until Kenneth Copeland got on the stand and said he committed a murder, right? And so, hopefully that doesn't happen. Hopefully Kenneth Copeland I didn't watch his full testimony after this, did not admit to something that he wasn't covered under, so that he didn't have immunity for. The defense attorneys didn't ask him about something that would get him in trouble or confess a crime. But it sounds like here they wouldn't be able to prove that anyway, because they don't know what Kenneth Copeland did and what he didn't do. Finesse is the exact right word, but I hope that makes sense about the independent evidence, the independent source. They have to get a source of that crime other than the testimony on the stand. And that's going to be difficult for the state to do, especially in a case like this one where they didn't know about the crime until the defendant testified about, or until the witness rather testified about it. Because if the state then goes and they try to look for that independent evidence, they try to look for proof of that murder. Well, guess what? You only look for proof of that murder because what I told you on the stand. You see what I'm saying? It's going to be hard not to trace everything back to that compelled testimony. And then right here, Kenneth Copeland is asking questions that need to be asked because the prosecution keeps saying they don't want him in jail. He says, if you don't want me in jail, why don't you just let me go? Why don't you just let me go after the trial is over with? And they said, well, you're going to be in jail because you're not answering the questions. So baby, it's not that they don't want you in jail, point blank, period. Here we get into more discussions about Kenneth Copeland's exposure. So he says, Ms. Hilton says, if you say something that you know you did not do, like you admit to something you know you did not do, whether, and Mr. Copeland says like murder, like no statute of limitations, right? Like murder doesn't have a statute of limitations. So you could indict me theoretically if I admit to a murder. And Ms. Bumpus says you can charge him with false statements and he'll be back in jail. That's what I'm trying to say. The prosecutor says, but if I know that you are lying about that, I do not intend to do that. If I know right now he's lying, I know he's lying, I'm not going to charge you with that because I don't know your reason for doing that. But I'm not going to charge you when I know you didn't do what you were trying to say you did now. So she's basically saying, if you are, say you committed a murder and you didn't commit a murder, I'm not going to charge you with that, or I'm not going to charge you with false statements, is what I think she's trying to say, but I don't know. That's a really interesting thing for a prosecutor to say. They really want this man's evidence. They're making all types of concessions for Kenneth Copeland so he can get on the stand and testify, only for his testimony to be not really credible or believable because nobody knows when he's telling the truth and when he's not telling the truth. Kenneth Copeland says, but it's up to the judge to do that, to bring charges for, I guess, false statements or things of that nature. And this Ms. Hilton says, no, it's up to the prosecution. Here we're wrapping up, we're coming around the bend, but here we say again, Mr. Copeland says he hasn't been able to talk to his family. The jail system is down. The state is still locking people up, knowing that he can't talk to anybody or that anybody else in there can't talk to anybody. Then we go here again where Mr. Copeland says, I told you every day before Friday came that I was pleading the fifth, again indicating that the state knew. The prosecutor is about to argue and the court just says, look, let's get beyond this. You could have invoked the Fifth Amendment privilege. The state could have turned around and said, stop, had me go ahead and file the immunity motion and given you immunity. So the state has decided that they want your testimony more than they do you invoking your Fifth Amendment privilege. So they gave you immunity and that's it. They gave you immunity. So you got to testify. At the end of the day, that's what the judge is saying. Here's the last piece of the transcript I'm going to talk about and wrap up from here. The judge says, Mr. Copeland, on page 2 of the order, pursuant to OCGA 24-5-507, this is the only part that will get you in trouble. It says, however, no testimony given by Kenneth Copeland as required under this order or any information directly or indirectly derived from the testimony of Kenneth Copeland given by Kenneth Copeland as required under this order shall be used against said Kenneth Copeland in any proceeding or prosecution for a crime or offense concerning which he testifies under this order. Okay, so you testify about some aggravated assault or murder. They can't prosecute you on it because that is what it says in this order. Okay, the only thing that will get you in trouble is this next little paragraph. Kenneth Copeland shall be subject to prosecution or to penalty or forfeiture for any perjury, false swearing, or contempt committed in testifying or failing to testify in accordance with this order. The judge essentially says those are the only things that'll get you in trouble. So perjury, false swearing, contempt committed in testifying or not testifying, refusing to testify, those are the things that will get Kenneth Copeland in trouble. The judge is going over that again, and that's what they talk about for essentially the remainder of the transcript. And that pretty much, I think, wraps it up. I mean, the judge says there's no sentence. I'm not going to sentence you to 100 days. You're just going to stay in there until you testify. So it does sound like exactly what Brian Steele said happened. I got to pull my fuck ass wig back so I can tell y'all I'm serious about this. It sounds like, exactly what happened. There was witness manipulation. Is what it sounds like to me. That's my humble opinion of this case, in that Kenneth Copeland is being told, hey, if you don't testify, then you're going to sit in custody. And it's clear, it seems clear and apparent to me that Kenneth Copeland didn't understand the full extent of this consequence of this immunity deal until afterwards, until he found out that he was just ordered to testify because he was given immunity. That's something that the state can do. So that is the long and the short of the transcript in this case. Y'all saw me read those together, child. I'm tired. I'm gonna log off today. Let me know if you have any other questions, and I will see y'all next time, hopefully with more energy.